recording at this point. This will be made available later to people who couldn't join us live. But I'm going to start by just kind of introducing this event and then talk a little bit about the CLS Fellows program before we get into our main program for the day. So this is the first in what I think we hope will be a series of foundation events. Anton, who's the director of law student programs with CLS National, has this kind of great vision for giving law students this some encouragement and instruction about how to make that transition from being a 3L to being in your first year of law practice. And there's a lot of questions that law school doesn't answer. A lot of moral questions, a lot of questions that we think about, especially as Christian law students. And so this is one of those talks that we want to use to kick off the series. And I think Professor Cochran is perhaps the best person to start us out with this, with all of his expertise in the field. I'm really excited to start this out with morals in law and law practice, because it should bring up a lot of really interesting topics that are on our minds as Christian future lawyers. So let me, without further ado, introduce our main speaker today. Professor Bob Cochran is the Louis D. Brandeis Professor of Law Emeritus here at Pepperdine University. He's the co-author of Agape, Justice, and Law, as well as the author of Law in the Bible. He's the founder of Pepperdine's Herbert and Eleanor Newtbar Institute on Law and Religion. He's also the co-founder of the Global Justice Program, recently having traveled all over the world to be a part of that. When he used to teach here at Pepperdine, he taught torts, legal ethics, religion and the law, and family law. And one of my favorite quotes from Professor Cochran is, "I teach because I think the truth is important. My hope is that in interaction with my students, we will discover the truth." So hopefully we'll do some of that truth discovery today. We're really excited to have Professor Cochran speaking about one of his upcoming books and talking about morals in the law and legal practice. So I will go ahead and turn it over to you, Professor Cochran, or as he likes to be known to the students, Coach.
Well, hello to all of you. I want to especially thank Rebecca, Tyler, and Anton for putting this together. I'm honored to be asked to be a part of it. It is also sort of self-serving on my part. As Rebecca said, I'm going to present part of a book that I've been working on, and I'm very interested in hearing your responses to parts of it. The book is called, or will be called, at least tentatively, The Ordinary Practice of Law as a Christian Calling. My thought here by the term ordinary practice is not that the people who show interest in it would be ordinary people or ordinary lawyers, but I want to focus on ordinary practice. I mean, the type of practice that most lawyers engage in on Wednesday afternoons in small towns and in big cities. So often, Christian lawyer conferences will focus on people that are engaged in international justice or human rights litigation or constitutional cases, First Amendment. But that's a very small percentage of the Christian law professors that are out there. And so the rest of us, people who practice as I did, when I was in practice doing a general litigation practice, in the morning searching a title, in the afternoon representing maybe a criminal defense appointment. What is it about what we do that might be a Christian calling, or should we be doing something else? So in the first 5 chapters of the book, I talk about, I have separate chapters on clients, on business lawyers, on trial lawyers, on the counselor at law. And talk about what ordinary practice looks like and how you can bring your faith to that practice and how engaging in that practice might be in some ways a service to God. I present a I mean, I try and present a straightforward picture of what lawyers do and its value to both the kingdom of God and to the culture in which the lawyer is practicing. And I'm very positive about the contribution that lawyers make, both business lawyers and trial lawyers. I mean, business lawyers, it seems to me, are exercising dominion on God's behalf. They're helping clients decide what businesses will start, how they will be continued, how people can be employed, how goods and services can be given to folks. I mean, that's a high Christian calling. Litigators are involved in addressing the challenges created by the fall, trying to resolve conflicts that in another setting might be violence, might yield violence. So litigation, sometimes we talk about alternative dispute resolution as being a healthy alternative to litigation. Well, I mean, I think it is, but remember, litigation is an alternative to something that might be quite worse. And so litigators in our adversary system play a role, but I think it's a role that's extremely important, and it's a system which, in a rough sense, in a fallen world, most often leads to just results. Certainly the alternative, which you see in countries that don't have the rule of law and are caught up with groups involved in military conflict back and forth. I mean, that's likely the alternative. And then the counselor at law, the counseling role. I mean, most often, I think lawyers as counselors help clients to see what the rule is. Their counsel leads clients to comply with law. I mean, I think that's a very important role as well. But here in this last chapter, I'm addressing the moral challenges of law school and law practice. I mean, I've addressed some of those all along the way in the book, but here I'm pinpointing some that I think are particularly challenging, or can be particularly challenging to lawyers. And so the book in general is very positive about law practice. Here, I'm identifying several things that I think you just need to be aware of. And I'm trying to root them in law school and your experience in law school. And I'll just say that I think a lot of these things are really endemic to the practice of law and law school. In other words, there's not a way to avoid these things. Part of learning to be a lawyer, part of learning to do the things that I mentioned earlier, part of doing the things that I mentioned earlier involve these moral challenges which you may face. And I think being aware of them is half the battle, because I think for most of these, it's very easy to just sort of slide into them. So just to identify them at the first, but first of all, I'm going to give you some homework. So I'm going to identify 6 challenges that I think are present and that are out there. And I want each of you to identify at least 1 or 2 of these that you see being the biggest challenge for you. And at the end, I'm going to sort of bring you all onto the screen, and then we can, I'll address each one and maybe have you through a show of either electronic or real hands indicate where you see the challenge. That'll be helpful to me because I'll get a sense of what law students, what sort of rings true about what I've shown. And so let's see, let's take a look at slide 1. Rebecca's going to be helping me with the PowerPoint. And so here I've got a list of these. This is just sort of a table of contents of the topics that I'm going to be addressing today. So you can be thinking about these, just which ones of them at first glance are something that you struggle with. So insensitivity, or that would be insensitivity to other people, kind of a depersonalization that might arise. Cynicism about truth, or cynicism about the efficacy of law. Pride, more in the sense of kind of personal pride, self-focus. Aggressiveness, lack of candor, maybe both things that arise often within the adversary system. And then finally, insecurity. I'm actually going to mix it up a little bit. I think I'm going to move pride to number 5 and the others up above. But we'll see as I go. Maybe I'll decide I want to vary them as I go. Well, anyway, I mean, one part of what you might do is to sort of, through self-reflection, think about these, but also think about what the people that you know best might have said about you since you started law school. Are people saying, well, you've gotten kind of cocky since you went to law school. You're more aggressive. You know, you've lost your idealism. You've become a little more cynical. Sometimes you get insight into these things through your parents or your spouse or your friends, if they're really good friends. Thanks, Rebecca. So our first one I'm going to address is insensitivity or depersonalization. I mean, as Rebecca said, I taught criminal law and I taught torts at Pepperdine, so I know exactly how this goes. To some extent, I'm pointing a finger at myself. You get to law school and you read your first maybe 10 or 20 cases in torts or criminal law, and you think, oh gosh, this is terrible. Here's somebody's, this old couple has lost their home, or this child's been killed, or someone has lost their sight, or this person from a really disadvantaged background now winds up spending the rest of his life in prison. And so that lasts maybe 10, maybe 20, maybe 30 cases. And then you get caught up in the routine of law school. And so now when you read one of those cases, you're thinking, well, is this element established? And what were the elements of assault and battery again? I remember when I spoke at Pepperdine a few weeks ago, I raised this point, and Professor Jennifer Coe, who one of my favorite people in all the world. I'm saying that not because she's listening in, but because she really is. But she shared a wonderful thing, and that is that one of our students, when she was teaching a criminal law class, in which one of these tragedies was presented, asked, "Is there a place for lament in criminal law?" I just think that's a very moving question when everybody else is trying to think, well, what's the issue in this case? There's a person that's being sensitive about the effect of the whole story on maybe the victims, maybe the defendant as well. Well, a professor used to be at Berkeley, John Noonan. Later, he was a circuit court judge. He wrote a book many years ago called Persons and Masks of the Law, where he pointed to the tendency of law to cause people to, or cause lawyers, I guess, in particular, to put masks on people and to put a mask on themselves, not the COVID masks that we've been wearing a lot in recent years, but really to to make people out to be something less than they are. And he took the Palsgraf case, and probably just about all of you studied the Palsgraf case. In tort law, you remember a lady gets damaged as she's waiting for a railroad, and the suit's brought against the Long Island Railroad. Well, Judge Noonan pointed out that Justice Cardozo, who wrote the opinion, never identifies Mrs. Palsgraf by name. We wouldn't know her name except for the style of the case and the fact that Justice Andrews identifies her by name. Now, when you're writing briefs, you're probably even worse. I mean, I've taught my students even worse. We don't even use the word plaintiff and defendant. By the time you do a brief, it's reduced to P and D, right? And I know your first couple of days in classes, a professor like me might call on someone to give the facts of the case, and the poor students, the first ones that I'd call on, they would sort of drone on and on and on with all the facts in the case. And I see some of you laughing. You can think of your briefs, your early briefs were anything but brief. And so the professor teaches you how to identify an issue, how to focus the facts that you're identifying on the facts that are relevant to the issue. But all that depersonalizes typically the parties that are involved. The description of the damages, I mean, unless damages is an issue, which usually is late in the semester or late in the first year, the damages kind of get lost on the side. Well, I think that's an important part of learning to be a lawyer. Learning to think like a lawyer is to focus your attention on, what issue and what facts is this case going to turn on. But what I want to do is to just make you aware of the effect that might be having on you, and maybe even on your character, and for you to stand against that, and to be aware that might be happening to you. And believe me, the same thing will happen in law practice. You'll have 8 appointments in a day, and this will be the 30th person that you've handled one of these types of cases on, and they're describing their injuries, and you're quickly sort of moving ahead. Well, is this a permanent injury? What would the damages be? Can I establish liability, et cetera? And that, if that's happening, I start to say it's not a good thing. Maybe it's good that you are focusing on those, because you need to be able to ask the right questions in order to represent your client. But if that process is making you insensitive to the injuries that do exist, and if you're coming to see this person as a $100,000 retainer, or potentially a $500,000 personal injury recovery, or an interesting antitrust case, or a boring trust and estates case, I think something's been lost. I think the remedy to that is we find in the early chapters of Genesis. Let's first talk about an old trial lawyer's rule. This is a rule that I teach when I taught trial practice. If you really want a jury to remember something, you tell them 3 times. You tell them in opening statement what you're going to tell them. Then you tell them through the evidence. And then in closing statement, you tell them what you told them. Well, in a sense, God does that in his story of the creation of humans. So let's take a look at slide 3. Here we have Genesis 1:26 to 27. So just 2 verses, but notice what God tells us 3 times here. And just to highlight it, to make it easy, I've put it in bold and I've numbered them. Then God said, 1, let us make human beings in our image to be like us, so they can reign over the fish in the sea, the birds in the sky, the livestock, all the wild animals on the earth, and the small animals that scurry along the ground. So, number 2, God created human beings in his own image. Number 3, in the image of God, he created them, male and female, he created them. Humans aren't just a chance collocation of atoms. I mean, they're not, quote, human resources. You know, could there be a worse title that you'd give to the personnel department in a business? But that seems to be the trend, to refer to people who work for you as human resources. No, they're precious. They were created in God's image. This is captured actually by Justice John McClain in the Dred Scott case. Let's go to slide number 4. Hopefully, those of you that have had con law, when you read the Dred Scott case, they included the dissent of Justice McClain. And hopefully they included this phrase, because I think it's one of the most powerful statements in the U.S. reports. As probably all or most of you know, the Dred Scott case was one where a slave was claiming that because his master had moved and taken him into a free territory, that he was entitled to freedom, but the majority of the court held that he was property, and so that the owner was entitled to keep him. Well, Justice McClain very powerfully says, so God says, a slave is not a mere chattel. He bears the impress of his maker, and he's destined to an endless existence. That phrase, the impress of his maker, quite a picture of what the image of God is. And of course, 4 years later, the United States was at war over this principle. So, thanks, Rebecca. So, push against this, respect clients, the lowest criminal defendant that you represent, the most arrogant CEO that you represent, were both created in God's image and deserve the appropriate respect in light of that. Look around for opportunities to serve people that might have been neglected, but people who were created in God's image. Many of you will settle in cities that have Christian legal aid programs, and they'll be looking for volunteers. And it's a wonderful way to be able to reach out to people and show the respect that they deserve. And then, as you deal with clients, bring them into the decision-making process. Some of them will expect you to just be one more person that's telling them what they should do. Show them the respect of these being their cases and their lives that are being talked about. So the first one, avoid the depersonalization that's going on. I think a lot of times as a result of what's gone on in law school. So number 2, cynicism, or what Dean Tony Croneman called losing one's soul. In the case of some law students, there's a couple of places where I think law students often become cynical while they're in law school. You see a lot of law students coming to law school, and they're very idealistic. They want to go out and change the world. A few years later, they've given up on that notion, and I realize financial pressures may put push people in that direction, but sometimes they've lost all sense of idealism. So they're not hopeful about law. They're very cynical about the legal system and whether there is such a thing as truth and justice. Well, I think a lot of that comes from first legal theory, and then secondly, maybe even the Socratic method. So first up, cynicism and legal theory. It's very interesting to read about the two leading big schools of legal philosophy that I think that both arose in the last half of the 19th century and continue oftentimes with sort of divisions that have broken off that are continuing their legacy. But if you look at the writings of both the law and economics movement and the critical legal studies movement, both of them trace their roots to Justice Oliver Wendell Holmes. Well, Justice Holmes, and let's take a look at the next slide. This will give you just a little flavor of Holmes and his cynicism. But I mean, there's a wonderful book called Law Without Values by Albert Alschuler, law professor at Northeastern and then at NYU, about him, and it shows the powerful impact not for good that he had on legal philosophy in the 19th and in the 20th, and I think now on into the 21st century. So at one point, he wrote a letter, and in the letter, he revealed, I mean, he was always saying things like this, but this was particularly striking. He argued moral preferences are more or less arbitrary. Do you like sugar in your coffee or don't you? So as to truth. I mean, it's just a matter of, your arbitrary thoughts. He talked of his own moral values as his can't helps, things that are within you that you can't help but have. Nothing rooted in anything deeper. He said that when people started talking to him about justice, he knew they had nothing interesting to say. And he completely discounted both truth and justice as a notion. And then, 30 years after he'd written this letter, we have him deciding the Buck versus Bell case. He had a number of decisions, none as cynical as this one. But those of you that have had con law probably read it. I hope you are outraged by it. But in it, Carrie Buck, a woman just slightly mentally disabled, had a child, and the state of Virginia, under a statute, without her consent, had performed an operation so that she could no longer have any children. Statute referred to her and to others like her as mental defectives, and the statute allowed them to sterilize them. Well, Holmes had a way with a phrase. It wasn't a good way, but this phrase, 3 generations of imbeciles is enough, I think, has to be the cruelest phrase in the U.S. reports. Well, the biblical message is that there is such a thing as justice, and that humans are created in God's image. There is such a thing as truth, and we as lawyers should work to try and identify it. Well, and I'll quickly say, by the way, that the law and economics movement and the critical legal studies movement have a lot to say. I mean, there's a lot of value, I think, to law being efficient. I think critical legal studies and their various offshoots, including critical race theory have really valuable insights about our tendency to, law and economics, the value of efficiency, critical legal studies about the tendency of humans to prefer themselves, critical race theory, the tendency of people to prefer their own race. But for law and economics, it's all about efficiency. For critical legal theory, it's all about power. There's no justice that's looked to. There are not the higher ideals. It's just a matter of gaining power and seizing power and using it. I guess the word I would use for both of them is that they're reductionistic. They take what should be the beautiful landscape of truth and justice, and they reduce it to a few things. It's more than that. Well, secondly, I think the case method tends to encourage cynicism. And Dean Anthony Kronman, he was the dean at Yale, now a professor at Yale, was the one who pointed this out in a very powerful way in his book, The Lost Lawyer. Well, I won't read the quote that I've got, but he's talking about the case method. Of course, you've all experienced the case method. You're given a case, a set of facts. You're asked to argue one side, then you're pushed to argue the other side, and you get kind of whipsawed back and forth, identifying the strongest arguments for each. He points out that for some students, they experience a level of cynicism, at best stoicism, at worst a level of cynicism growing out of that. They come to believe that there's not really any truth, there's just arguments to be made on either side. Well, again, I think the Socratic method is a wonderful thing. I think the Socratic method can teach law students to think carefully through their arguments, through the arguments of the other side. I think you can do that for legal cases. You can also do that for your moral convictions. It's important to recognize the strongest arguments for the other side, and then maybe reformulate your views in light of that. Maybe respond to it. Maybe it'll strengthen your views. But for Christian students who are looking for the truth, I think that sort of exercise may help you to find the truth. Don't just stop. If you're kind of lost and you figure, I just can't figure out what's right here, don't just give up and assume that there's no truth here. Hang in there and seek to understand what God's mind would be. God was the inventor of truth, beauty, and goodness and justice. And I think the Socratic method should not lead to cynicism, but should lead to iron sharpening iron, to us having a deeper appreciation of, a deeper understanding of what truth might be. Well, I want to leave time for our discussion, so I think I'll work maybe a little more quickly through these next few notions. The adversary system, I think, is a wonderful system. I think it's a system designed to be an application of practical wisdom, a system designed to identify what truth and justice would be. I worked for a circuit court judge. He felt best about decisions that he made when he had good briefs that were done on either side, when each side was presenting its strongest case. And I tried a number of jury trials. I think the jury benefited most when they had the strongest arguments placed on either by either side. Well, I think playing your role within the adversary system is a good thing, but I think it can come with a certain level of moral cost. I'll highlight particularly a certain aggressiveness. I mean, you're called on to be an aggressive advocate. Some of you may have had your favorites your favorite people may have said, you've gotten a lot more aggressive since you went to law school. Some of you may have had people say obnoxiously so. And then I remember a case where I was negotiating. It was negotiating over for a client. She had sold a horse which had been shipped overseas. It was a quite expensive horse. Well, on the other end of the line, it turned up lame. And so the one who had purchased it was alleging that she had shipped it fraudulently, knowing that it was lame. She said, well, I didn't have any idea it was lame. Must have happened during shipping or after it got there. So we were looking at litigation for it. And I can't remember what the figures were if we were to just say maybe it was $100,000 horse. And I explained to my client, she wanted justice, but I said, you've got some exposure here. I said, you might lose 100,000 on this case. She recognized she might get a lot of bad publicity, even if she won it. But we talked and we concluded the settlement value might be $50,000 for the case. The guy on the other side was not represented, and he wanted to save money and handle it himself. He's off in another country, and I was representing her. And those of you that have had legal ethics, that sort of setting, I can negotiate directly with the party on the other side. There's not a lawyer to negotiate with. So we arranged a telephone conference, me and the opposing party, and my client was sitting right there in my office, and I turned it on speakerphone. I didn't identify the fact that she was there listening in, and it was just me talking with him, and we got started talking, and he wanted to settle for 100,000. And I said, oh, well, there's no way you're getting 100. He quickly came down to 50,000. I said, this case isn't worth 50,000 in settlement. It's barely worth the settlement for the fees that I might charge. And then he said, well, would your client take $30,000? And I said, 30,000, that's outrageous. Of course she wouldn't take 30,000. And my client, her eyes are lighting up. She's getting excited by all this negotiation and the way that it's headed. And, we might have settled the case for $15,000 or $20,000. Well, I was very proud of myself. My client was very proud of me. In the back of my mind, I thought, well, I sort of exaggerated. I'd sort of told falsehoods as far as my value of it, as far as what my client would take for the case. But mostly, I was proud of myself as a young lawyer for having won the case and having my client so thrilled with me. Well, then a few days later, I was talking with my wife, and my wife, Denise, she was hoping we could do something on Saturday that was something I didn't particularly want to do, wasn't all that interested in. Maybe it was to go shopping with a friend, with one of her friends, or to one of the little towns in the area. And I said, well, no, I've got to work. I've got a trial coming up next week. And she says, oh, well, okay. Well, I didn't have to work. I've always got work that I can do. I wound up working that day. But what I realized was I was sort of sliding into that kind of adversarial mentality in my life, that it was sort of bleeding over into my private life. And I recognize that there's a danger in that. Now, what I've done in the negotiation is specifically approved by the model rules. Negotiation of where you argue about, assess your value, your client's willingness to settle. Those are specifically identified as not being material matters, but I recognized that just sliding even into something that was approved was affecting my character. I mean, Christians are called on to be candid, to be open about their lives. Well, there are a lot of areas where you as a lawyer can't be candid. You hold confidential information for your client. In negotiations, in trials, you may be hoping that certain facts don't come into evidence, even though they might be valuable, those valuable to the other side, and even though they may be truthful. These are part of the game that's been established. I even hate to call it a game, or I hate to call it a war. I mean, those sort of war or game analogies kind of glorify it in, I think, silly ways. The adversary system is an important system, and those rules are in place for, I think, important reasons. And it's a system that ultimately, I think, is likely to yield truth and justice in most cases in this fallen world. I'll argue that maybe some of the rules should be different, but I think a lawyer's participation in the adversary system is a good thing. What I'm suggesting, though, is that you should be aware of the effect that your involvement might have on your character. What I hope people will be have faithfulness in your role, that you'll see the value that your role might have to a system, that you'll look to the broader impact of the system, that you'll see that it's good for you to be a part of this system, but to be aware that there might be dangers to your character in this. And this may be an over-dramatized example, but I thought this argument was particularly helpful. Many of you may know who Dietrich Bonhoeffer was. Bonhoeffer was a pacifist Lutheran pastor in Germany. When Hitler came to power, he'd written very powerfully about pacifism, and yet he saw what was happening to Germany in World War II and with the rise of Hitler, and he shifted, or at least in the circumstances of Germany, he very much shifted to the other side, and he joined the opposition, and in fact joined an assassination plot, a group that was trying to assassinate Adolf Hitler. Well, in a sermon, he talked to those who were involved in the resistance with him. He, by the way, was killed just shortly before the U.S. forces came in and liberated the camp where he was placed. But here's what he said in this sermon to his colleagues. He says, "We've learned the art of deception and of equivocal speech. Experience has made us suspicious of others and prevented us from being open and frank. Bitter conflicts have made us weary and even cynical. Are we still serviceable?" Again, maybe over-dramatized to use his example here, but there's these dangers in law practice. And then he says, it's not the genius that we shall need, not the cynic, not the misanthropist, not the adroit tactician, but honest, straightforward people? Will our spiritual resources prove adequate and our candor with ourselves remorseless enough to enable us to find our way back, again, to simplicity and straightforwardness? Now, I love a couple of things about that. I think he's recognizing that it's important just to recognize the danger. If you recognize the danger, I think you're halfway there. That is, that advocacy, protection of client confidences, et cetera, may make you more aggressive, may make you less straightforward. So he's being candid about that, but notice that his term is us. I mean, it seems to me that he's focusing on addressing these in a communal context. And Dietrich Bonhoeffer, by the way, wrote a classic Christian book called Life Together. And I think in the backdrop of this is the need, the importance of being aware of these things, working together to address things like this, being a part of a CLS group, being part of a group maybe within your firm where we'll hold one another to account. Well, next among my dirty half dozen, you might call it, is pride. I'll draw our attention to pride. Maybe we could go to the next slide. And I think it's helpful to look at, this is slide 7. I'll start working toward the matter of pride by first talking about the world, because I'm really going to build my argument on 1 John 2:16, which addresses the world that surround us. Of course, John 3:16 says we're to love the world, speaking of the people in the world and the world that God made. But John and Jesus also used the world to refer to the systems of this world that might draw us away from faithfulness to Christ. So do not conform to the world. And there's so many wonderful translations of that. Don't let the world squeeze you into its mold, Phillips' translation says. And I'll move forward a little bit. 1 John, here you've got John, who of course also wrote John 3:16, is identifying what's meant by the world: the lust of the flesh, the lust of the eye, and the pride of life. My friend Bill Heatley describes that what John is warning us of is the world's promise of enabling us to feel good, look good, and to be superior to other people. So the flesh, the eye, and the pride of life. Well, I think all of those can be problems for attorneys. Attorneys wind up in situations where you're tempted, maybe tempted to take advantage of clients. I want to focus though on pride. Because I think often this is a problem for attorneys. Law school is made up of people who've been successful. People within the culture look up to lawyers. I think a lot of times people choose law school because they want to be looked up. When you get into law school, you begin to move up. It's law review. It's an editor in law review. It's getting a clerkship. It's moving to the right firm. Each step along the way, however far you get that ego boost. Law is inherently competitive. C.S. Lewis points out that pride is competitive as well. Pride is looking down on those who you've succeeded over, who you've done better than. I mean, pride was actually the sin that brought me to look for help from Christ. So in a sense, I'm kind of thankful to pride. Lewis, one of my favorite quotes from him, he says, as long as you're proud, you cannot know God. A proud man is always looking down on things and people. And of course, as long as you're looking down, you cannot see something that's above you. Lewis identifies it as the greatest sin. Some of you may know Mere Christianity. That's his chapter on pride, the greatest sin. And he gives, I think, a really helpful, so do you denigrate the good things that you've done? I mean, I think false pride is about as obnoxious as pride itself, maybe even more so. But Lewis says when something good happens, you should rejoice at the same level, whether you're the one that does that good thing or whether it's someone else who does that good thing. I think that's a good test for us. Are we rejoicing as much at our friends' successes as we are, and even people who aren't friends' successes as we are at our own? If not, we need to pray about it. Finally, insecurity. I think insecurity, ironically, is often coupled with pride. I mean, if you're enjoying looking down on other people, you're probably insecure about people that are looking down on you. And of course, law school's always one more mountain to climb, getting into law school, law review, class rank, clerkships, bar admission, big firm, partner, the big neighborhood, the right clubs. There's never really a stopping place. If pride on one hand is your goal and insecurity is driving you. I love from Hamilton, Aaron Burr's song, "The Room Where It Happens." If I were my dean, Paul Cochran, he would have a music clip for us. But anyway, the room where it happens, where you probably, most of you know that Aaron Burr is just so resentful that he's not in the room where Hamilton, Jefferson, and Madison are working out this deal that's going to, sort of drive the country forward. And in the musical, the chorus mockingly sings, "What do you want, Burr?" And then 6 times he sort of pitifully says, "I want to be, or I gotta be in the room where it happens," showing insecurity, though he's one of the most successful politicians and lawyers in the country. And C.S. Lewis refers to that as the inner ring. Google C.S. Lewis and the inner ring. He's got a lot of wonderful insights on the desire that people might have to break into that inner group, that group that's got the status, that's kind of the cool people, the more important people. Well, this is all for a lot of people, I think, neurotic. You're looking for status when it's maybe rooted in other things. Ultimately, it's a question of identity. Where do you find your security? Where do you find your significance? And with that, I'll just remind you again of my first slide and the thing God told us 3 times, that humans are created in His image. Let your image of yourself be the one that God tells you is your image, and that is His presence within you. And for those of you who are Christians, probably all of you, of course, the New Testament notion of you being a child of God, a very important notion that should be our source of identity, our source of significance. If so, we won't have to worry with insecurity. We won't think about things very much. We can just go on and live and enjoy our lives and care for the people around us. So for both clients and for you, this notion of God's image, very important. Well, I've left a little bit of time for questions. Maybe we could have maybe 10 minutes of questions, and then we'll break. But first, I want to get sort of a show of hands about what, as I said, I'd like for each of you, let's see if I can get the right view. Is there a way I can get gallery view on, there's full screen. There we go. There's gallery view. I see a few of you there, but maybe those of you that don't, that aren't on the screen could use the other function. Pick one or two of these, what I've identified as moral challenges, and I'm just curious which one draws the most attention. So just to run through all of them again: insensitivity, cynicism, aggressiveness, lack of candor, pride, and insecurity. So a show of hands, electronic or real. Insensitivity or depersonalization. For which of you did that ring true? Cynicism. Who become more cynical while you've been in law school, or at least that that's one. So Darren's saying he can't pick one. So had one vote there. Aggressiveness. Got one. I don't know what everybody's saving up for. A lack of candor. You find yourself sliding into to that. We got a couple of you. And pride. Who's struggling with pride? Well, you're spread all over the place. Three of you, I think, have identified that. For Hannah's giving me a quick little wave. So pride a little bit. And how about insecurity? Okay, a lot of you dealing with insecurity. You're seeing that as one of the real challenges of being a law student and being a lawyer. Well, let's see what questions or comments you might have, and I'm quite happy to hear either questions or comments. I love being a law professor because I learn so much.
Yeah. Well, we'll start with Coach. First of all, thank you so much for sharing. I really love that your title is coach, because that's really what that talk felt like. You preparing us for the next quarter of life, which is going to be coming up after law school and even during law school. So first of all, just thank you for that and for your words of wisdom here. I've been collecting a couple of questions from people in the chat as you've been going. So I'll start with those. And if people have others, they can stick them in the chat, or you can raise your hand, and I have to unmute you manually. So just know that there might be a little lag there. But I want to start with this one I received in the chat, asking about this insensitivity factor, and whether, first of all, you think that maybe appellate work is even more of a trap for insensitivity because you're further removed from the facts. You know, at that point, it's no longer a question of fact, it's a question of law. And it seems like it might be easy to forget that there are real people involved in those situations. So what do you think about that, and about, you know, how we could even fight that in appellate law?
Yeah. Oh, that's such a wonderful insight. And I think you're right. I've never really thought of it in those terms. But of course, if you're doing appellate work, you're removed from the person. In a sense, appellate work's more like law school. You're just reading appellate cases and reading about people that have experienced these things rather than actually interacting with them. If you're a trial lawyer, I mean, even if you're an appellate lawyer, you may be meeting with clients, and so you may be hearing clients' personal stories, and so that may come home to you, what's going on. But if you're doing trial work, you're hearing both sides, and sometimes a very compelling story comes from the victim of maybe a criminal defendant that you've represented. So the trial work and actually meeting with clients at the beginning comes as a bit of a slap in the face. I can remember some of the very early clients I met. They'd tell me their stories, and I'd be so sort of off into their stories, and then, oh, this person's looking to me for some guidance. In law school, you tend to view clients as occasions for advocacy, not as real people. So I would say that can be a problem. And I think just trying to think in terms of these people, maybe you're just reading their name on as the style of the case, but thinking about them and thinking about what they're going through. But I just highlight that that's a wonderful insight. Of course, part of my message is just that getting insight to these being dangers, you're halfway there. The real problem is when you don't even recognize this as a problem.
Yeah, that's a really good point. I guess the first step is recognizing the problem. Another question I got is closely related to this, and I think you've touched on this a little bit. Sometimes it feels like in practice, perhaps you're not really engaged in the discovery of truth because you're, looking for the version of the story that best fits your case. And so how should law students prepare to deal with that so that they don't become cynical, especially when we're just we feel like we want to pursue the truth, but when you're being paid by a particular client to kind of push a particular angle or story, it feels kind of wrong. So what would you respond to that?
Yeah, I think you stated the problem very well. I think, again, identifying the problem is a big part of it. I think seeing yourself as a part of a system and not more than that is helpful. Not feeling bad about being part of a system, because I think it is a good system, a system that ultimately I think is most likely in this fallen world to lead to the best combination of truth, justice, and protection of rights. But your role is to try and, sometimes you'll make a mistake. One of the things that the system is designed to do is to give you a role. So your job is to explore the facts from your client's perspective and to speak for your client. That's one thing I haven't emphasized here. I've been giving more of a systemic argument for the advocacy system. But I think there's also an individual argument for it, that your focus is with this client, and you may be the only person in the world that's on this client's side. That's particularly the case in horrendous criminal cases. I did two murder cases, and these people were all alone, except for me. That's pretty pitiful. But standing with them when they were called on to plea, standing with them when they received the verdict, I felt like I was the only companion to this guilty person. And I think that's an important role to play. That I've sort of gotten off onto a tangent there, but I think an important one. But to recognize that your role is to tell this person's story when very often they're not very articulate. They can't tell their story. Maybe you're telling their story and you don't really believe it. And you're telling their best understanding of the facts. In some ways, you're kind of like an actor. One of the exercises I do in my some of my classes is to read a thing about actors and lawyers. You're sort of like an actor. Well, an actor who's playing a prostitute in Les Mis isn't a prostitute. They're helping to tell a story, a very powerful story, a story that's about truth and justice. And in some ways, I think a lawyer is kind of like an actor, is a spokesperson for someone who might not speak so well, wouldn't understand the law. I guess some students, some lawyers are uncomfortable with that role, but I think it's a good role, and I think the affirmation that you should receive is the affirmation of you being part of, ironically, a team of advocates, a team of opponents in a sense, each of whom is playing a role. And I mean, in the end, when my clients maybe would get convicted or I'd lose a case and I'd walk away, and sometimes I'd say, well, justice was done, but I did my part in making sure that it was done, even if I lost.
That's really, yeah, Lakita took the words out of my mouth. That's great insight, really helpful for us. Does anyone else have other questions? Darren, let me see if I can unmute you. Oh, can you not be unmuted? Let me try again.
Hi, sorry, that was my mistake. As soon as you unmuted me, I muted myself for some reason. I meant to take the hand down. So I have an idea why you want them to call you coach. I'm guessing that it's maybe you think of yourself more in that type of role. It's just a random guess. So I don't actually have a question, but I did want to make some comments, and I thought maybe you can respond. But first, I would say, I came here for a book signing. And I don't know how we do this virtually. We figured out everything else, except I don't know how we do book signings virtually. Well, editorial book signings. Thank you. Yeah, that works. So when you started on this list, I thought, I read it, I read the terms, and I thought, I don't have a problem with any of these things. I mean, that's not really, an obstacle. That's not something that, that I struggle with. And then I heard kind of like you presenting the rule and the analysis and saying, this is actually what it is. This is how it plays out. And then I identified 5 out of 6 things that it's like, oh, I can see this fitting into my life right now. But then afterwards, so once I heard you talk a little bit more on each one, I realized, oh, but then there's some tools with it. Some of these I'm exercising and some of these I'm identifying already, which is good. And so that's when I deviated from the so-called call of the question. Instead of just picking one thing to go with, or instead of just saying, okay, this is the problem with it, I said, okay, here's the negative aspect, here's the problem, and then here's the tool. So I've got in my list, I've got 5 or 6 things with a positive and a negative. And I think that's the feedback, or that's the comments that says, I mean, I don't know what an author does. Should I put this out there? I mean, I think this talk is showing kind of what this might do for somebody like myself. and I like to refer people with books too. I mean, I've got a lot of examples. I don't want to get into them, but I will say for humor, I think the most interesting one to me is the insensitivity, because I thought there's no way I'm insensitive. You know, I'm a very empathetic person. I love to give my time to people. And then I thought about, well, what area of law am I doing? You know, all this other stuff, I can see it in everyone else. And then there's myself. So what if I'm making it so it's tax, just like Dean Cochran, or Dean Karen. So in tax, you make decisions based on the tax outcome. Not everyone likes that, but you know, if this is not a good idea to have this, this separate entity functioning over here, then you know we want the tax savings. Well, what about the people that live over there? You know, what about the jobs? What about, you know, the people who are being served by this entity? No, it's just flip it over and you know, do something else. So it's very relevant to me. All of them are. And yeah, and I'm really glad that I got to listen to this today. Oh, and since I'm on the topic, thank you, Rebecca, moderator. Interestingly, I just met one of her colleagues this morning. And I thought that was kind of neat, you know, how some kind of timing works sometimes.
Good. Well, thanks, Darren. And maybe I'll get you to send me an email with your comments, and I can send it to publishers. I haven't started circulating my book yet, but that was very encouraging to me. By the way, as I've thought about the timing of when students started calling me coach, and my liking the term so much and encouraging, it was just at the time that my youngest son stopped playing baseball, and so maybe I enjoyed coaching my kids so much that it was a nice reminder of when I did that. But what I tell students is that it's my picture of what a professor should be. I mean, what's important in my relationship with students is not so much what I do, it's what you're going to do. I mean, to the extent I can help you, motivate you, push you, care for you in a way that's going to enable you to succeed, I'm a good coach. But what's important is when you get out there and start practicing, in the case of a lawyer.
Well, thanks for.
Yeah, this is the tools. Thank you. Sorry, Rebecca.
No. Thanks for that, Darren and Coach, for responding. I know we're getting to be a little late here. I know it's getting late on the East Coast. We're getting a little nice Malibu sunset here. So I want to just wrap us up a little bit with a final question, and then let you go. But you know, one thing I was thinking as we were going through all of this is there are all these problems with the law. It's riddled with some of society's worst problems, and they're so inherent in law school and in the practice of law. I wonder what you would say to, is it worth it? And if so, why? And another way to phrase that might be, is there any redemptive value in the law?
Oh, I think absolutely so. And yeah, there's challenges, but you look at the good ways that I think law has evolved over the decades and centuries. I mean, I think one thing that's important, again, is seeing yourself as a little piece in a movement that's, on balance, I think, a very, very positive movement. It wasn't that many years ago that there was slavery, or African Americans or women could not vote, and that criminal defendants could be beaten to get a confession out of them. I mean, there's in my view, hopefully there's some positive movement that'll take place through Supreme Court opinions this very year that we can be excited about. And it's not very often that a lawyer sees his or her case make some big significant change, but being a part of the law, the implementation of the law, very important. You mentioned that I had done some traveling for Pepperdine in recent years. By the way, maybe on my website, I should remove recent. It's been in the last 10 years or so. But about 10 years ago, I went to Rwanda for Pepperdine. And one of the things that I did was to go with another Pepperdine professor who was over there at the same time. And we went to the church at Intamara, which is the remains of what was a Catholic church, where several thousand, a small building, but where several thousand people crammed into the church during the Rwandan genocide. I mean, you had this breakdown in law and order, and I mean, to just see what they had done with this church, where they thought they were going to go and they might have safety, that there would be respect for here's a church building. Well, they weren't. Bombs were thrown in, people were hacked with machetes, including babies, and they took the clothing as they took the victims and were cleaning them, and they piled the clothing, the blood-stained clothing, in the aisles of the church. And then they took many of the skulls, hundreds of skulls of babies and adults, old people, some of them with hacked machete marks in the skulls, and they put these in cases and just that lined the wall. And they did all this, of course, as a memorial to these people whose lives had been sacrificed, but a stark reminder of what happens in a situation. To my mind, the lesson was in a situation where law and order breaks down. There's been times in my life when I've been very discouraged at, say, a Supreme Court decision that's come down. I can remember one time in particular, and I can remember talking with a friend, John Whitty, who's very much involved in the law and religion area, and just saying, I'm just, sort of ready to give up and go, join some church that's isolated, that rejects law. And he says, don't do that. The value of law that we all experience, that our neighbors experience, that our friends experience, is much more than most of us imagine. And in fact, involvement with law, whether at your level as a lawyer, all the different levels, police officers, judges, legislators, is, and I think should be, really an act of love, because when you see a situation where it's just been removed, it's horrible. So I'll leave everybody with that thought. Hang in there.
I think that's a great place to end. We want to thank you so much, Professor Cochran, for speaking this evening. This is a great way to start off the Foundation series. We hope anybody else on the call will join us for future series. I think we've got a few more of these coming up in the next couple of weeks. So thank you so much.
Thank you, Rebecca.
Thank you so much, Bob.